The U.S. Supreme Court confronted the nation's homelessness crisis on Monday, wrestling with the legality of local laws that are used against people camping on the street and in public parks. The case involves the vagrancy policy of Grants Pass, Oregon. The city appealed a lower court's ruling that enforcing its anti-camping ordinances against homeless people when there is no shelter space available violates the U.S. Constitution's 8th Amendment that prohibits cruel and unusual punishment. Liberal Justice Elena Kagan appeared ready to side with the homeless plaintiffs who challenged the city's laws, telling the lawyer for Grants Pass that they went too far.
This is a super hard policy problem for all municipalities. And if you were to come in here and you were to say, we need certain protections to keep our streets safe, and we can't have, people sleeping in any place that they want, and we can't have, tent cities cropping up, that would create one set of issues. But your ordinance goes way beyond that. Your statute says that person cannot take himself and himself only and, can't take a blanket and sleep someplace without it being a crime. It seems like you're criminalizing a status.
Liberal Justice Sonia Sotomayor asked the lawyer for Grants Pass where the homeless were supposed to go.
It is.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
Some of the conservative justices seemed hesitant to conclude that the ordinances violated the 8th Amendment. Conservative Chief Justice John Roberts raised doubts that homelessness can be considered a status that would prohibit enforcing local laws.
You can remove the homeless status in an instant if you move to a shelter or situations otherwise change. And of course, it can be moved the other way as well if you're kicked out of the shelter or whatever. So that is a distinction from all these other things that have been labeled status.
Conservative Justice Brett Kavanaugh suggested that an alternative recourse for homeless people who believe they were unfairly impacted under the local laws would be to mount a defense under the legal theory of necessity, arguing they had no other option.
If a state has a traditional necessity defense, won't that take care of most of the concerns, if not all, and therefore avoid the need for having to constitutionalize an area and have a federal judge superintend this rather than the local community, which you've emphasized many times, working with the nonprofits and charitable and religious organizations, which is how it works in most places?
A ruling by the Supreme Court, which has a 6-3 conservative majority, is expected by the end of June.